My name is Chua, and this is my presentation for the Public International Law assignment. In this presentation, we will address two questions posed by the Prime Minister of Mandalore, which includes 1. An explanation of the first optional protocol to the ICCPR and what would be the impact of being a party to this protocol for Mandalore, and 2. Explain on what is a reservation in the law of treaties and address the possibility of entering into a reservation to Article 1 of the optional protocol. International law plays an important role in providing for and safeguarding human rights. The development of human rights laws are highly reliant on treaties as the main source of binding agreement and understanding between states to protect fundamental rights. The International Covenant on Civil and Political Rights, the ICCPR, which Mandalore intends to enter into as a party, is one such example of a human rights treaty whose main function is to protect the political and civil rights of persons, guaranteeing rights such as the right to self-determination, the right to life, freedom of expression, and many more. Although the essence of the ICCPR is its role in human rights, but its legal power lies in its form as a treaty. Treaties are international agreements concluded between states in written form and governed in international law, and can be contained in a single or two or more related instruments. There can be many terms used to describe international agreements concluded between states, such as conventions, protocols, and etc., each having a slight difference but are generally grouped under the term treaty. The first optional protocol is also a treaty, taking the form as a protocol which establishes additional rights and obligations to the original treaty it is related to, in this case the ICCPR. It is subject to independent ratification as parties do not automatically become a part of it, hence it is optional. And those who are a party to the optional protocol establishes between themselves an additional framework of obligations built upon the general treaty. The optional protocol to the ICCPR provides for the power and authority of the Human Rights Committee to also establish an individual complaint mechanism in addition to its roles as provided in Part 4 of the ICCPR. Therefore, if Mandalore enters into the optional protocol in addition to the ICCPR, subjects under its jurisdiction may file their own individual complaints regarding actions or legislations of the state, Mandalore, which violates their ICCPR protected rights to the Human Rights Committee. These complaints are filed in their own individual capacity after they have exhausted all available domestic remedies. The impact of ratifying and accepting the supervision of this body in relation to individual complaints is as follows. 1. Mandalore is obliged to provide written explanations or statements within 6 months to the committee as a response to any complaint received and reviewed by the committee. 2. Mandalore is also obliged to not hinder access of the individual in submitting their complaints to the committee and is also required to not take any retaliatory measures against the person. 3. The state recognizes the competence of the committee in determining whether there had been a violation of rights or not. 4. Mandalore is required to act in good faith and cooperate to provide an effective remedy in case the committee finds that there is a violation of rights. In conclusion, the first optional protocol to the ICCPR is an independent international treaty which requires separate ratification from the ICCPR. It provides for an individual complaint mechanism in case of state violation of rights protected, and being a party to this optional protocol shall require Mandalore to give explanations for individual complaints against allegations of breach of rights, refrain from hindering access to complaints or take retaliatory measures, recognize the competence of the committee to make findings in relation to the question of whether rights have been violated, and to cooperate and act in good faith to effectively remedy violations of rights. And now we come to the second issue on whether Mandalore can make a reservation on Article 1 of said protocol. A reservation, by definition, is a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in their application to that state. The rationale for this is 1. From the state's point of view, it may accept to be bound by the treaty, but not all of its provisions, as it may be in conflict with their domestic laws. And 2. From a universal point of view, the flexibility provided by reservations enable more states to enter into the treaty, thereby achieving universal participation, which helps to strengthen those laws internationally. The few articles in the Vienna Convention on the Law of Treaties, hereinafter referred to as the VCLT, which govern reservations are Articles 19 to 23. Article 19 provides for impermissible reservations, which can be differentiated into those which are expressed within the treaty itself, either by direct prohibition through Article 19A, or only allowing reservations to be made on certain specific articles, thereby prohibiting reservations to be made on other provisions, through Article 19B. The other category is found in Article 19C, where reservations are impermissible due to its incompatibility with the object and purpose of the treaty. Since the adoption of the General Comment number 24 of the Human Rights Committee, which made a few comments on its practice in relation to reservations to the ICCPR, the law had been inconsistent as this decision deviated from the VCLT, which is undesirable. In the comments, the distinction between normal treaties and human rights treaties were drawn, wherein it was commented that human rights treaties concern individual rights as compared to interstate exchanges of mutual obligations. Therefore, having states be in full control of the reservation status on something that affects individual rights is not suitable. They concluded that their practice on reservations shall be as follows. 1. The treaty monitoring body is the authority in determining objectively whether a reservation made is compatible with the object and purpose. And 2. If a reservation is incompatible, then it shall be severable, and the reserving party shall remain a party of the treaty without the benefit of the reservation. Therefore, the International Law Commission, in response to this and several other issues, conducted research on the reservation of treaties. Through the Guide to Practice on Reservations to Treaties published in 2011, the ILC has affirmed the approach in General Comment number 24 and further clarified it, while also establishing this guide as universally adaptable to treaties not only limited to human rights. This is the current standard of practice in relation to reservations. 1. International bodies which have the competence to assess whether a reservation is compatible with the object and purpose of the treaty includes the states themselves, dispute settlement bodies, and also treaty monitoring bodies. The competence of each in assessing is without prejudice to the competence of another. 2. When a reservation is found to be incompatible, that reservation is null and void. 3. The reserving state has the right to decide on whether they intend to continue being a party to the treaty without the benefit of the reservation, or if they do not want to be bound by the treaty by expressing contrary intention. So the default position is that reservation is severable and that state remains a party. Therefore, the current practice is that if a reservation is found to be incompatible with the object and purpose of the treaty, the reservation will be void, and the reserving party can choose to either continue being a party to the treaty without the reservation or decide that he will not be bound. There is no middle ground for interstate modification of treaty through acceptance or objection when it comes to impermissible reservations as per Article 19C of the VCLT. Now, applying the law, can Mandalore make a reservation on Article 1 of the optional protocol to the ICCPR? To address this problem, we need to decide on whether such a reservation is impermissible under Article 19. As stated previously, the optional protocol establishes an individual complaint mechanism. For subjects within the jurisdiction of participating states, they can submit their complaints on alleged violations of rights protected under the ICCPR, which then empowers the committee to request written explanations from the state and express their views after investigation on whether any violation of rights had occurred. Article 1 of the Optional Protocol verbalizes this recognition of state parties regarding the competence of the Human Rights Committee to receive complaints. Therefore, making a reservation on this provision essentially undermines the entire function of the committee's individual complaint mechanism. The Human Rights Committee themselves have declared via the General Comment Number 24 that any reservation that seeks to preclude the competence of the committee in receiving and considering individual complaints will be contrary to the object and purpose of the optional protocol. Therefore, from the strength of the above, it is clear that entering into a reservation on Article 1 of the Optional Protocol is legally impermissible due to that reservation being incompatible with the object and purpose of said treaty. In conclusion, for the state of Mandalore, being a party of the optional protocol to the ICCPR shall give the Human Rights Committee the competence to receive and consider individual complaints regarding violation of ICCPR rights by Mandalore. Mandalore is also obliged to cooperate and act in good faith with the committee to give explanations and conduct effective remedies. Furthermore, making a reservation on Article 1 is impermissible as it is contrary to Article 19C of the VCLT as being incompatible with the object and purpose of the optional protocol. That is the end of this presentation. Thank you.